everyone, this is Carrie. Welcome in. Thanks for joining me. So we had some interesting updates this week. Actually happened on Monday with the Highland Park attackers' circumstances. I guess you should say circumstances surrounding his case. His father, Robert Cremo Jr., had been charged with signing an application that allowed him to buy a weapon. And obviously, we all know the outcome of that. His father was facing several felony convictions that could resulted in substantial time in jail for him. And basically, he pled out this week, which it dwindled down to misdemeanor convictions and 60 days in jail with 2 years probation. Legal experts say that this should have no effect whatsoever on his son's trial. But as we've been diving in on this channel, we've been diving into the parents and how they are somehow connected to what happens. I mean, they are the parents of these young adults doing these things. And I just find it important that we do show this because I do plan to dive more in depth on the Highland Park attacker. It's a very troubled young man. So we're gonna watch the proceedings now. And if you want more information surrounding what's going on with this case, I do have a playlist on my channel, and I will link it at the end so that you guys can click and go in directly into it.
The state of Illinois versus Robert Cremo Jr., 22 CF 2074. The defendant is present out of custody, represented by his attorneys George Gomez and Ilana Meyer. The state is present through state's attorney Eric Reinhardt and assistant state's attorneys Todd McCutcheon and Jeff Facklin.
All right, this matter comes on today for bench trial. Parties update me.
Yes, Your Honor. First of all, because your instruction was so clear regarding Sam Cremo, the record should show that Mr. Jed Stone is here on behalf of Sam Cremo. Okay. We have other updates for you, but I think Mr. Stone felt that he should be here.
Judge, I represent Sam Cremo. I don't think I need to say more than that because what's going to happen, I believe, will moot any issue with Mr. Cremo.
Okay. Thank you, Mr. Stone.
Your Honor, the other update is that over the weekend, the parties have reached a negotiated plea in this matter for your consideration.
All right, and what is that?
The negotiated plea would be that in exchange for a plea of guilty to 7 counts of misdemeanor reckless conduct, obviously the state would be amending its felony class 4 reckless conduct counts to 7 counts of reckless conduct class A misdemeanor, which we would seek leave to submit to you. We have the written information. The defendant would be placed on a period of 2 years probation with standard conditions, 100 public service hours, open mandate for treatment, no FOI, no firearms, surrender sane, and he would serve 60 days in the Lake County Jail.
All right, have the victims' families been consulted about this?
Extensively.
Mr. Cremo, is what I just heard from the attorneys your understanding of this agreement?
Yes.
Has anyone promised you anything I did not hear about?
No.
Is anyone forcing you or coercing you in any way to make you do this?
No.
You're entering pleas of guilty to 7 counts of a Class A misdemeanor, all of which are punishable by up to a year in the county jail, a $2,500 fine, or both. Do you understand that?
Yes.
Are you under the influence of any form of alcohol or drugs?
No.
Are you taking any prescription medications?
Blood pressure.
Okay, just blood pressure. Okay. You understand by entering this plea of guilty today, you're giving up your right to have a trial before this court or in front of a jury of 12 people, which you've already waived that. At that trial, you would be presumed to be innocent of the charges against you, which could only be overcome if the state could prove that you were guilty beyond a reasonable doubt. You would have a right to confront and to cross-examine the state's witnesses, to testify on your own behalf, and to call your own witnesses. You understand by pleading guilty today, you're giving up those rights.
Yes.
And the court costs are set forth in the court order, a separate order. The financial sentencing order, the court finds that those court costs are statutorily authorized, and you have to have those paid over the next year. Are you going to get that done?
Yes.
And the court finds that the defendant has an ability to pay them as well. Factual basis.
Thank you, Your Honor. the parties stipulate and agree that if called to testify, civilians and sworn law enforcement of the Illinois State Police would testify that on December 16th, 2019, Robert Cremo Jr., the defendant, signed and executed an affidavit in support of his son's application for a fire owner's identification card. At the time of this application, his son, Robert Cremo III, was only 19 years old and could not acquire a FOID card without parental sponsorship. Records from the Illinois State Police would show that the defendant's affidavit was submitted as an attachment to the FOID application of Robert Cremo III. Illinois State Police personnel would testify that Highland Park Police Department submitted a clear and present danger report for a review in September 2019, including allegations of conduct by Robert Cremo III that could not independently be confirmed or substantiated through their investigation, that there was no probable cause for an arrest of Cremo III, that there was no information indicating Cremo III had access to firearms, that Cremo III had no FOID card or pending application, that knives voluntarily given to Highland Park Police at the time were subsequently returned to the defendant when the defendant claimed that those knives were his property and not the property of Cremo III, and that consequently Illinois State Police law enforcement personnel had legally insufficient evidence to establish a firearms prohibitor. The Illinois State Police would further testify that absent any firearms ownership legal prohibitors, and in the absence of the defendant reporting conduct of Cremo III known to the defendant, constituting a clear and present danger, the Illinois State Police by law relied upon the written affirmations of the defendant that there was no reason Cremo III should not have access to firearms. Illinois State Police personnel would further testify that Robert Cremo III's FOID card would not have been approved without the defendant's sponsorship of the affidavit as required by law. Finally, Robert Cremo III's FOID card was approved and activated in late January 2020. Witnesses would testify that at the time the defendant sent the sponsorship affidavit to the Illinois State Police in December of 2019, the defendant was aware of the following: that his son had sent suicidal text messages as recently as September 2019, according to a forensic analysis of Robert Cremo III's phone, that the Highland Park Police Department had received information about threats to the family from Robert Cremo III in September of 2019, that the Highland Park Police Department had received information about Robert Cremo III expressing suicidal ideation in April of 2019, and finally that Robert Cremo III had expressed an interest in committing a mass shooting to Young Life Camp personnel in 2014 or 2015. Witnesses would further testify and establish that on February 6, 2020, Robert Cremo III purchased a Smith & Wesson M&P 15 rifle with serial number TM49842. That on February 7th, Robert Cremo III presented his FOID card to Bud's Gun Shop in Lexington, Kentucky to acquire that weapon via an online interface. Witnesses from Red Dot Firearms would testify that Robert Cremo III presented his FOID card on February 13th, 2020 to take physical possession of the Smith & Wesson M&P 15 rifle with the same serial number I listed above. The parties stipulate that the defendant, because he knew more than the Illinois State Police as set forth above, was aware of the substantial risk to others when he signed the FOID sponsorship form in December of 2019, and that through these actions, he endangered the safety of Catherine Goldstein, Irina McCarthy, Kevin McCarthy, Stephen Strauss, Jacqueline Sue Sundine, Nicholas Toledo Zaragoza, and Eduardo Uvaldo, when Robert Cremo III obtained the M&P 15 on February 13th, 2020, and discharged the firearm that he purchased at each of those individuals on July 4th, 2022, at the Highland Park Independence Day Parade.
So stipulated?
So stipulated, Your Honor.
All right, and Mr. Cremo, once again, do you feel that you have had a sufficient opportunity to discuss this decision with your attorneys?
Yes.
Have they answered any and all questions that you've asked them?
Yes.
And based on all those conversations and your review of the evidence, do you believe that it is in fact in your best self-interest to enter this plea?
Yes.
All right, the court finds a sufficient factual basis in knowing and voluntary waiver of the right to trial, and the court will accept the negotiation pursuant to that in 22 CF 2074 for the offense of reckless conduct, multiple counts, which is a Class A misdemeanor. I'm going to place you, sir, on 24 months of probation with the standard indicia probation, 60 days in the custody of the Lake County Sheriff, 100 hours of public service, pay the court costs of this case, Surrender your FOID card and any other ammunition that you may have. You're not to sponsor any other minor children for FOID card applications in the future. The case will terminate on November 5th of 2025. And obviously the other charges are superseded by the additional counts of the information.
This one's going to be brief. We're not going to be taking any questions at this moment. Obviously, there's a lot to digest in regards to all of this. But again, there's not going to be any questions in regards to this, but we do have a statement for today. The result of today's proceedings provides a fair outcome to my client and the community of Highland Park. As part of Mr. Cremo's defense team, we fought tirelessly to defend Mr. Cremo in every step of this process. My position has always been to try this matter due to the facts and circumstances of this case, and also given how this case was being charged. As you all know, this matter was going to be tried first before his son's case was going to be tried. This would mean that the potential key evidence would be disclosed to the public, jeopardizing his son's fair right to trial. As a father, Mr. Cremo wanted to ensure that his son received a fair trial. Additionally, it appeared that as we got closer to trial, that the state strategy required pitting Mr. Cremo's family against each other. Mr. Cremo ultimately did not want his family to be more torn apart on the public stage than it already is. Also, Mr. Cremo also took into account the community of Highland Park. As a member of that community, the last thing Mr. Cremo wants is the Highland Park community to relive these tragic events and make a public spectacle of this. Even if this matter were to go to trial, it would never change the tragic events of what had occurred on July 4th. Mr. Cremo has always, since the inception of what had transpired that day, has always provided grief, expressed his condolences to all those that have been affected by that tragic event. My client believes that it is in the best interest of his family and the community not to publicly relive the tragedies of the 4th of July shootings, especially in a public trial. Thank you.
Thanks for watching, everyone. Please don't forget to check out the other videos in this case on my channel. And if you liked this video, please do comment below or click that thumbs up. It would really help me out. Y'all have a blessed day, and I'll be back really soon.